Morning, everyone. This is a contentious issue, one I've reported on before, and I think that this is newsworthy. There was a press conference held yesterday talking about some People's Party candidates who have put forward a private members bill. So this is not a People's Party platform plank. This is a private members bill by People's Party candidates. And I think that's important. And because abortion is and has been a very hot button issue. Well, Trudeau's already been bringing it up. This is going back to May, where Trudeau was using abortion as a fundraising tool. Here's CTV News reporting. Liberals fundraise on abortion rights as Trudeau criticizes U.S. backsliding. This is when Vice President Pence was visiting, and this was a big deal. And here's a part of the article, just a little bit. The Liberals issued a fundraising email blast Thursday raising the, quote, alarm about 12 Conservative MPs who went to an anti-abortion rally on Parliament Hill last week. The email directed supporters to websites for the 12 Liberal riding associations working to unseat the Conservative MPs, whom the party accuses of trying to reopen the abortion debate in Canada. Okay, so they're saying very clearly in that statement, we're not going to reopen the abortion debate in Canada. Those guys are. And here's Andrew Scheer saying, nope. And the CTV article also notes that Scheer has denied repeatedly, or has pledged repeatedly to not reopen the debate. That's what the article says. So, and here's Andrew Scheer, again, saying the same. Here it is.
Distract from their record of failure. Very, very clear. Canadians can have absolute confidence that a Conservative government after the election in October will not reopen this issue. Stampede is fantastic.
Sorry about that. And so you've heard from Andrew Scheer and you've heard from Justin Trudeau. Liberal fundraising is essentially hearing from Justin Trudeau. And well, here's a couple of People's Party candidates who would bring a private members bill. We're going to look at the private members bill. We're going to look at the morgantaller decision. We're going to listen to a couple of clips from this. So this is a little bit of a long one, I guess. First of all, I wanted you to hear from somebody other than me that this is not a People's Party of Canada plank. This is a private members bill. Here we go.
By Lynn Thompson and Paul Mitchell, if either one of those were to become elected in the federal election. This is not tied to Maxime Bernier or the People's Party platform or policy. This is basically giving the constituents and the members of these ridings the chance to voice their concern and vote for a party that believes in protecting the unborn.
And so I wanted that to be perfectly clear. If you want your local candidate to sign on to this, and again, I'm going to show you the website. Here's the website. It's proposing to be nonpartisan. It's proposing to be reaching across the aisles because they're trying to put forward a bill that they think is very center, very what the Supreme Court intended at the end of the morgantaller decision in 1988. And we'll get there in a minute. I'm trying to encapsulate it all, but I'm hoping to have the understanding here that this is supposed to be across party aisles. It doesn't matter if you're a Conservative MP or an NDP MP. And I mean, everybody in the Liberals has had to sign a pro-choice, so it's not likely that they'll support something like this. But at the same time, they could if they wanted to, if they were allowed to by their party whip. Right. So, I mean, there are limits, but it's true. You can make your own choices in life. So here is, I'm going to get the next clip queued up. It'll be a bit of a long one, but here we go. Okay, this clip is laying out the fact that there are no abortion laws in Canada. It talks about the 1988 morgantaller decision. It talks about late-term abortions and exported late-term abortions. I've got an article to back that up as well. It's got stats for late-term abortions and how many people are sent and how much that costs. It goes into several dozen Canadian patients per year. Sorry, that was a note for me. But you'll see all my notes. All my notes are in the description. And if my notes aren't in the description, all of my notes are posted on my website, CanadaPoly.com, so you can check them out there. Just search the title of the video, and it'll bring up all of the stuff. I'm working on a bumper, but I've got so much to do. Okay. Anyway, back to this. It talks about funding from provincial governments. It talks about the Supreme Court and the intention of the judges at the end. And we're going to look at the intention of the judges at the end with proof. And so I think that's where I'm going to stop it and get back in, but it's about 4 minutes. So, well, here we go.
To begin, there is a lot of confusion in the Canadian public about what is and isn't legal according to federal law with respect to abortion. I have spoken to many Canadians who had absolutely no idea that there was no abortion law in Canada, and that 7, 8, and even 9-month full-term abortions are legal. Canadians are quite shocked to find this out. Since the 1988 Morgantaller decision by the Supreme Court of Canada, we have had no Canadian law on abortion. While it is true that provinces and the Canadian Medical Association have policies, that is not the same as having a law, since health policies are with respect to the health of the pregnant woman, while an abortion law would protect the rights of preborn babies. Unfortunately, late-term viable preborn babies with physically healthy mothers can be killed through abortion in Canada. Canada even exports late-term abortions to the United States when no Canadian doctor can be found, and some doctors abstain due to conscience rights.
I'm just going to pause it here because I want to show you that this is happening. Here's this global news, May 28th of 2019, how the wave of U.S. restrictions will affect Canadian Women's Center for Abortions. And I've just highlighted a specific part here. There's a chart. It's a handy chart. It says, quote, part of the challenge is the restrictions and lack of access in Canada to late-term abortions, which the Canadian Medical Association defines as anything after 20 weeks of gestation, says Dr. Dustin Kodusk, got your name wrong, a family planning specialist with the Department of Obstetrics and Gynecology at the McMaster University. When you're talking about an abortion after 20 weeks, basically Vancouver, London, Ontario, Toronto are the main centers that do these later abortions. A few smaller centers might do them, but they also wouldn't advertise, so it's difficult for women to know where to access these services, he said. And the number of late-term abortions sent from Quebec, I believe this is from Quebec specifically, in the year and the cost and the number. So in 2014, that's good. In 2014, there was 2015, there was 33 cents, and that cost $326,000, and that's a lot of money, right? In 2015-16, $294,000 for 26. 2016 to 2017, $287,500 for 20, and then 2018 to 2019, $347,900 for 26. So this is something that is affecting you and I. We're paying for this through taxes, through health benefits, right? This is funding that could be going to earlier term abortion, funding that could be, there's lots of other uses for this, but I found this really surprising. I did not know when I found this out, and which is why I covered this in the first place, why I did my first video in the first place, because I thought, what's the history of this? How did we get here? You can look in my back catalog to find my first video on this, because I was interested and I wanted to look into it, and I did. Back to Laura Lynn.
While the exact numbers are not easily found, according to Patricia Maloney, there were in 2013 and 14, 780 stillborn abortions and 161 live birth abortions past 20 weeks, and some past 28 weeks. Other pregnant Canadians seeking abortions beyond 24 weeks were being referred to specialists in the United States. Here's a quote from an article on Canada.com. Dr. Warren Hearn, a so-called late-term abortion specialist based in Boulder, Colorado, says he sees several dozen Canadian patients a year. He has no upper limit in terms of how late he will perform an abortion. According to the Abortion Rights Coalition of Canada, as of February 2019, with respect to U.S. clinics doing late-term abortions, it says such procedures and associated expenses may be funded in full or part by some provincial governments. The time has come to debate this in Parliament. In the 1988 Morgantaller ruling, the Supreme Court of Canada said very clearly, the state has a compelling interest to defend the unborn. There are a number of Supreme Court quotes in the preamble of the bill that we wrote, and you should all have copies today. The judges of Canada's Supreme Court expected Parliament to replace the law that was struck down with another law which would pass the test of fairness. This has never been done.
And I'll pause her there. All of that is interesting to me, from the late-term abortions to the funding from the provinces for that specifically. And that's what this proposed bill is targeting, specifically late-term abortions. Okay, I'm going to queue up the next clip and I will be right back. Okay, here's a bit more of Laura Lynn.
Across this country during the 2019 federal election campaign, it cannot yet be defeated. It can be debated. It is our sincere hope that what is beginning here today in Red Deer with two People's Party of Canada candidates will soon be sweeping the nation and beginning a dialogue that will result in the legislated end to late-term abortion in Canada. To strengthen our fight for a legislated end to late-term abortion, we invited the local Red Deer Conservative candidates to join with the People's Party candidates, and in so doing, virtually guarantee that our bill would make it to Parliament Hill soon after this fall's election. We believe strong.
They didn't show up. So I will queue up the next clip. Hold on a second. Okay, and I'll let Laura Lynn finish off her speech here, and then there's another speaker that we're going to look at a couple of things that he says.
Today, we break that silence. And it is with great appreciation that we see a new day dawning in Canada, where one political party leader, Maxime Bernier, makes it possible for open debate, common sense, and rational discussion on this issue. There is only one leader in Canada who will do that.
Okay, and I'll queue up the next one. Hold on. Here's Paul Mitchell, and he's taking the stage. He was talking at the beginning about how disappointed he was that the Conservatives didn't show up, and he starts talking about the bill. So here we go.
So what's our bill about? First of all, I'll start with what it isn't. It isn't an end to legal abortion in Canada. It isn't a bill that tries for perfection. It isn't a bill that answers the ultimate question, when does human life begin? What our bill is trying to achieve is very simple. The bill is an attempt to find common ground. We hope that all Canadians will find it is very reasonable. We're even hoping that many Canadians who are pro-choice for early-term pregnancies will come on board and support this bill. Canadian law should be about placing reasonable limits to behavior and protecting our society and our citizens. It should be about codifying shared values that Canadians can agree upon from coast to coast. Our bill will limit the legal availability of abortion in Canada to the first 24 weeks of a pregnancy. Why 24 weeks? Because by 25 weeks, the baby is viable and has a fantastic chance of long-term survival outside the mother. Viable.
I think that encapsulates it. This whole interview this whole press conference is worth watching. And I've got my notes in the description. And again, if you can't see them, go to my website and you'll see them there. There are questions at the end, 17 minutes, I believe, or 18:48 is the beginning of questions. There's some interesting questions. There's a lot of support, and it's interesting how the audience interacts, and then the questions they ask. So you can check out my notes for the questions. I'm going to leave this here. I want to look at the actual bill now. So here's the website. So here's the preborn website and the proposed bill. It's preborn.ca, and the proposed bill is here. And it is, I'm going to read it because I think it's important. So like I said, it's going to be a bit of a long one. It says House of Commons of Canada Bill C, and it doesn't have a number because we can't submit it until after the election if one of these two gets elected. Right. Okay. So first reading. Right. We'll go to summary. This enactment amends Section 287 of the Criminal Code to limit the lawful intentional termination of pregnancy to the first 24 weeks of the pregnancy to protect preborn children in the late stages of development. An act to amend the Criminal Code Section 287. Preamble. Whereas the preborn child is sufficiently developed to be viable with a high probability of long-term survival by the 25th week of development if delivered with proper medical care. Whereas Canada has no valid abortion law and the Supreme Court of Canada was unanimous in R.V. Morgantaller in 1988, finding that the state has legitimate interest in the protection of preborn children. Whereas Chief Justice Dixon and Justice Lamar, I'm not sure, concurring, agreed, quote, that protection of fetal interest by Parliament is also a valid governmental objective. It follows that balancing these interests with the lives and health of women, a major factor, is clearly an important governmental objective. Whereas Justice Beets and Justice Etste, concurring, wrote, Section 1 of the Charter authorizes reasonable limits to be put on a woman's right having regard to the state interest in the protection of the fetus. The next one is here. Scroll up, sorry. Whereas Madam Justice Wilson wrote, in the early stages, the woman's autonomy would be absolute. Her decision reached in consultation with her physician not to carry the fetus to term would be conclusive. The state would have no business inquiring into her reasons. Her reasons for having an abortion would, however, be the proper subject of inquiry at the later stage of her pregnancy, when the state's compelling interest in the protection of the fetus would justify in prescribing conditions. The precise point in the development of the fetus at which the state's interest in its protection becomes compelling, I leave to the informed judgment of the legislature, which is in a position to receive guidance on the subject from all the relevant disciplines. It seems to me, however, that it might fall somewhere in the second trimester. That's Madam Justice, I'll note. And I wanted to show that these are quotes from Morgantaller, and that's page 183, but here's the judgment of the Supreme Court of Canada. Link is in the description. And here is let's use the fast way, right? So the state would have no business inquiring into her reasons. Her reasons for having an abortion would, however, right? I just read that. This is from the decision. The intention was for the state to pass a law to replace the struck down law. But the law to replace it, which passed and was in Senate in 1992, collapsed because the government collapsed. Right? And nobody's ever touched it since. Very interesting stuff. Okay, back to this. I just wanted to show you. I'm going to show you another one from the same. Here's the other one from the same PDF, from the same decision. Historically, there's always been a recognition of public interest in the protection of the unborn, and there's no evidence or indication of general acceptance of the concept of abortion at will in our society. The interpretive approach to the charter adopted by this court affords no support for the entrenchment of a constitutional right of abortion, and so that's interesting here, and that's. Sorry, I thought that was one of these ones. But anyways, whereas Justice McIntyre and LaForest argued, quote, there has always been a clear recognition of a public interest in the protection of the unborn, and there is no evidence or indication of general acceptance of the concept of abortion at will in our society. The interpretive approach to the charter adopted by this court affords no support for the entrenchment of a constitutional right of abortion. Oh, okay, there it was. I did just read it. Ha! And so I wanted you guys to know that this is the intent of the Supreme Court was not to make abortion not have any law governing it. It was to get a better law. And that's Parliament's job. That's our elected officials' job. Okay, back to this. Whereas Canada's lack of any protection for preborn children is completely out of line with the laws of other democratic countries in the world, and no Western country with federally regulated abortion laws allows those abortions beyond 24 weeks. And whereas Parliament wishes to specify protection of preborn children in the later stages of development, now therefore Her Majesty by and with the advice and consent of the Senate and the House of Commons of Canada enacts as follows. Short title, this act may be cited as the Protection of the Preborn Children Act, Criminal Code, and then it goes through the amendments. I'm not going to read the amendments. I wanted to highlight the Morgantaller preamble. If there's interest in me going through the full law, I will, if there's interest. But at this point, I think I can maybe just highlight. Nope, I've got to read it all. Okay. No, 2871. Everyone who uses or attempts to use any means to terminate a pregnancy is guilty of an indictable offense and liable to imprisonment for a term not exceeding 5 years. Serious cases, every person who commits an offense under subsection 1 and A, acts without the informed consent of the pregnant person except in cases of medical emergency where the pregnant person is unable to consent, or B, recklessly causes danger of death or serious harm to the pregnant person or preborn child, is guilty of an indictable offense and liable to imprisonment for life and to a minimum of punishment of imprisonment for a term of 5 years. Person terminating their own pregnancy, everyone who, being pregnant, uses or attempts to use any means to terminate their pregnancy is guilty of an offense punishable on summary conviction. Definition of means. In this section, means includes the administration of a drug or other noxious thing, the use of an instrument, and manipulation of any kind. Exceptions. Subsection 1 and 3 do not apply where a qualified medical practitioner, before using or attempting to use any means to terminate pregnancy, has confirmed by certificate in writing that A, the qualified medical practitioner has determined the pregnant person is not more than 24 weeks into the pregnancy, B, the pregnant person is not being coerced to terminate the pregnancy, and C, the qualified medical practitioner has explained the significance of the intervention, especially about the order of events, risks, and possible physical or psychological consequences. 6, the limitation in paragraph 5A does not apply if the qualified medical practitioner has by certificate in writing stated that in their opinion the termination of the pregnancy is necessary, A, to save the life of a pregnant person whose life is endangered by a physical disorder, physical illness, or physical injury, including a physical condition caused by or arising from the pregnancy itself, or B, to prevent severe pathological physical morbidity of the pregnant person, or when the preborn child has a lethal abnormality or no cognitive function. 7, subsections 1 and 3 do not apply where a qualified medical practitioner, before using or attempting to use any means to terminate the pregnancy, has confirmed by certificate in writing that according to the bona fide opinion of a medical practitioner, A, an unlawful act has been committed against the pregnant person under sections 151 to 155, 265, or 271 to 273 of the Criminal Code, and B, the pregnancy resulted from the unlawful act. Information requirement. 8. The Minister of Justice must by order annually require a medical practitioner who has terminated the pregnancy of any person to furnish them with a copy of all certificates required in subsections 5, 6, and 7, and such other information relating to the termination of the pregnancy as they may require. Everyone who knowingly contravenes subsection 8A is guilty of an indictable offense and liable to a term of imprisonment of not more than 2 years, or B, is guilty of an offense punishable on summary conviction. Summary conviction is usually a fine. Requirement of consent not affected. 10. Nothing in subsection 5, 6, or 7 shall be construed as making unnecessary the obtaining of any authorization or consent that is or may be required otherwise than under this act before any using or attempting to use any means to terminate the pregnancy of a person. Definitions. 11. For the purposes of this section, qualified medical practitioner means a person entitled to engage in the practice of medicine under the laws of the province in which the termination of pregnancy occurs. Termination of pregnancy. Termination of pregnancy means the act of using or prescribing any instrument, medicine, drug, or any other substance, device, or means with the intent to end clinically diagnosable pregnancy of a person with knowledge that the termination by those means will cause the death of the preborn child. Preborn child. Preborn child means a child at any stage of development that has not yet become a human being within the meaning of section 223. There we go. So that is the abortion topic in a nutshell. And I think it's a larger nutshell than I intended, so I apologize for the length, but that's it. What do you think? What do you think? Is this a reasonable middle of the road suggestion? Is this wildly undoable? We can't do it. It's way out there. Or is this something that people left and right can kind of agree with and say, yeah, okay. What do you think? What do you think? Thanks for watching, everybody. Check out the peoplespartyofcanada.ca and have a wonderful, wonderful day.